we're going to go into some of the details associated with an issue that's really been presented to us a number of times. Typically, we would talk about a technical issue on asset protection, on corporate law, on tax law. This is really kind of a corporate law question, but it's become so prevalent that we wanted to do a presentation on it. A number of industries have been hit very hard economically by the crisis. Entertainment, events, restaurant groups, commercial lenders, commercial tenants, commercial real estate groups, that they've found themselves in a situation where they have a large commercial line of credit and they're paying on the line. Almost in every case we've dealt with, they're paying on the line. They're current, but there's a number of financial covenants in their loan documents. People think a loan document's like a little promissory note. I owe you $6. These documents are 6, 7, 8 inches thick and have all kinds of promises associated with the operation of the business, like liquidity and revenue and liens and all kinds of other issues that you agree that you will abide by, and if you don't abide by, it's a breach of the loan and you can actually be foreclosed on. So what we're finding is there's a lot of people in these technical breaches, and they've got to rework their loan documents or negotiate a new set of loan documents because a refinance may not be available. So that's what working it out, practical considerations for these commercial loan modifications is. Let's go to the overview, and we're going to take off our video so you guys can see the slides. Go ahead and click the video and move to the first slide. I'm going to turn it over. Kathryn Jones in our firm runs these transactions. We've had a number of them. They all go in kind of the same direction. We want to do it quickly, and the bank wants to make it into an international five-year journey. It's like the Amazing Race for them. It's not just getting to the finish. It's all about the expedition. So I'm going to turn it over to Kathryn. She's going to work through the agenda and take you through the different topics with Paige, and we'll comment on our personal experiences in a lot of these issues. Go ahead, Kathryn.
Thanks, Gary. Thanks, Paige. Thank you to everybody for joining us today. The agenda, this kind of gives us the 30,000-foot overview of what we're going to be covering today, and we'll get into further detail as we hit each of these points. Paige, if you could advance to the next slide, please. The first thing you kind of have to be aware of is the context, in that the borrowers are typically not in a great bargaining position to negotiate concessions. What typically happens is that the borrower may have obtained a large commercial loan or line of credit or a mortgage on a commercial building, and the first time around it wasn't that big of a deal. The banks are trying to obviously attract credit-worthy borrowers, and so on the first go around, when they're originally obtaining the credit in the facilities, there may not be a lot of back and forth with the bank. The banks are typically wedded to their forms, and the borrower in that instance is trying to get access to the capital. So on the first go around, there's not a lot. Really, sometimes counsel isn't even involved in the first go around. Where we have,
they may be starting up, and they just need the money, and just signing everything, whatever they need to get the money, and they find themselves later entangled in this covenant mess.
Right, exactly. And from the bank's perspective, when it comes time to modify something, let's say there's a hiccup or a huge pandemic as we're facing in the present day, when the borrower comes back, the bank may not really be inclined to renegotiate, because in their view, the borrower has already agreed to these terms and they're just working out a few small things. So when you're going into a situation with a modification, the borrower may already be in default. More often than not, our experience has been that it's been a technical default, like Gary said, a non-monetary default, something which may be somewhat innocuous in better circumstances, but for example, a client or a borrower may have not timely delivered financial statements or comply with reporting requirements under the loan documents. So they'd be in technical default even though there's no monetary default at such time. The modification may also be prompted by the expiration of a line of credit. Sometimes these lines of credit, even though they're for multi-millions of dollars, they may renew as frequently as annually. And so it may just be that it's up for renewal and the bank sees an opportunity to maybe perhaps get additional capital or get some additional security, or I'm sorry, additional security from the borrower that may not have been available at the time the original loan was made. In these kinds of extension situations, what we normally like to see is a formal extension of the term of the line, so the client doesn't feel like they're under the gun to just concede on everything with an upcoming expiration in the offing. Sometimes banks are not willing to do this, and they like to create that time leverage there for the client. But when possible, we'd like to perhaps document formally intention to an existing line of credit to give additional breathing room to the borrower. If the bank isn't willing to agree to an informal extension, that's typically, okay, so long as the client is comfortable proceeding on a somewhat informal basis, working towards an eventual modification and closing at a later date.
And you also, a lot of times there's a lot of pressure applied, but the reality is the larger the loan, the more pressure on the bank. I mean, we've got
Right.
the contractors like, if I owe you 5 million, it's my problem. If I owe you 50 million, it's your problem. So the pressure is, it's true that there be a time pressure with respect to the bank wanting the new security or whatever, but there's a lot of pressure on the bank because it's very uncommon that they would default out that line on someone who's actually paying on the line. It may take a little cajoling, but you typically will get the extension. Another reason we found for these modifications is, this client borrower went into the bank and got with someone who's no longer at the bank or whatever and signed a set of documents. They're loan documents, but they were applicable to someone who took a $500,000 loan, and they actually got a loan for $25 million. And they've been working with this for a while, and it's been annoying the bank because they've got the wrong documents, and now it's going to expire. So they actually want to move the client to a very onerous, a much more secure platform based on the $50 million loan. Just keep that in mind. If your documents, if you got a large loan now, you may be in financial default, probably don't look like what the bank wants now.
Exactly, and that leads nicely, Gary, into the next point 3 there, the bank being wedded to their forms. We in the past, we've in the last calendar quarter, we were dealing with a very large bank trying to get a modification done for a client, and the counsel on the other end was actually very candid as to their ability to accept or deviate from the bank's approved set of forms. That counsel told me that when they receive a credit agreement fresh from the bank, there's upwards of 300 footnotes in the credit agreement where there's specific instructions. You can accept this, you can't accept this is non-negotiable. So the bank has already directed the attorneys somewhat in the leeway they're allowed to have in negotiating changes. An example that I wanted to bring up was we actually in this deal, there was a general release of the bank, which is common. If the bank re-ups, they give a release to the client for any prior defaults, but they also want a pretty broad release coming back from the borrower. And the ask that we made was, okay, we're willing to give you a general release, but we want to carve out for any kind of fraudulent activity that may have resulted from the bank's part, and understanding that that's unlikely to have occurred, but we wanted to carve out just in case there was something like that we were not aware of. and the council wouldn't give it to us, even though it's probably a reasonable and a customary ask. But they were specifically directed not to make any changes to their general release language. So even a reasonable ask could be rejected simply because the bank doesn't want to deviate from their forms. Okay. Next up on the agenda is attorney's fees. This is something, and I think this is going to be very sensitive to the client, in that when the borrower goes in, uh, initially they may not have had lots of attorney's fees that they're paying for on their side. When there's a modification, typically the bank is expecting the borrower to pay for attorney's fees on both sides of the transaction. And so the best time to try to negotiate a cap on this is early on, um, when the business folks are talking about the modification at the business level. Uh,
No
and
doubt.
council may not be even involved until we get to the nitty-gritty and the legal documentation. But an example is if you have a borrower who has, as a multinational company, or they have or, entities formed in multiple states, you may have a situation where you have 3 or 4 law firms on each side. Multiply that by 2, and your client was paying for law firms to handle the transaction in some form or another.
On both sides.
In the situation that I'm thinking, on both sides, exactly. So you may have a U.S. based borrower who has operations overseas or has operations in multiple states in the U.S. And we'll get to this a little bit later, but where this becomes an issue is with legal opinions, and that their primary counsel may be, for example, licensed in Florida but not licensed in New York, which is the jurisdiction whose laws govern the terms of the loan documents. And so in that situation, if the bank does require a legal opinion, they will want a New York licensed lawyer to issue the legal opinion with respect to the enforceability of the documents under New York law, for example. If there's real property that is in states outside of the jurisdiction in which the main counsel is licensed, the bank may want an opinion regarding the enforceability of mortgages on that real property under the state in which the real property is located. So you can see where attorney's fees, it's not just each side pays their own. It really is the borrower pays both sides, and that could be multiplied depending on how many jurisdictions are implicated in the transaction.
And if you catch it early, you can use that. If you've got we just had a multinational one that we closed, and the client didn't involve us in the initial negotiation, but could have used that and say, look, we're going to have to pay lawyers in 3 countries, which they did. They paid lawyers in 3 countries. We're not really going to be able to pay the bank. The bank's going to say, for the bank's attorney, the bank's going to say, no, you have to pay our attorney, and then opens up the window, well, okay, we can pay your attorney, but we're only going to pay your attorney $50,000 or $80,000, whatever the number is, and then they negotiate that down, and they usually get it. They usually get a cap. In my experience, I think in our experience, they usually get a cap. In this particular transaction, the client was crushed with attorney's fees because the attorney's fees coming from the bank were absurd, especially in light of the fact that they refused to change it.
And they were starting with their forms, right? So again, going back to the bargaining position of the borrower, the bank being wedded to their forms, it was a little surprising to me anyway as to how quickly the fees on the bank side kind of ballooned in light of the fact that the bank wasn't willing to make a lot of changes, and they were really using their own forms and driving the documentation in the transaction. On the next slide, we want to put it in context, where if a borrower, they may be seeking a slight modification or just an incremental increase in the amount of capital that they have access to by a few $1,000,000. But even the cost of fees to get that few extra $1,000,000 may be grossly disproportionate to the value the client is getting. And so just to keep in mind that, your client may be only getting a few extra $1,000,000, but legal fees could run 10% of that or more. Depending on the number of law firms involved and also the billing rates of the law firms involved. We're not in a position to control or even know what the bank's attorneys are charging. but that just makes it more important to negotiate up front a cap if at all possible. Moving on to the next bullet point are some of the key provisions in the credit agreement from the borrower's perspective. Again, with the understanding that the borrower really isn't in a position for the most part to make any significant changes, but as a practice, we like to go through the credit agreement pretty thoroughly and advise the client as to potential exposures or things to be aware of, even if they're not in a position to change them, at least they're aware of what's going on and can anticipate potential issues that may arise in the future. One of the areas of exposure are the representations and warranties that the borrower is making. This is really the factual basis for the bank's loaning of the funds and making their credit decision to lend. The reps and warranties are usually very, very onerous and must be true when made, continue to be true throughout the term of the loan, and true with respect to all loan parties. So if you have a situation where you have, two primary borrowers and a bunch of subsidiaries and they're all cross guaranteeing everything to secure the bank, those reps and warranties are multiplied by the number of entities that are making those reps and warranties. So some key areas that we like to focus on are regulatory, legal, securities, and tax compliance representations, environmental matters, things that the borrowers may not necessarily be aware of as far as a breach. One of the ways you can mitigate exposures under these types of reps and warranties is to use knowledge qualifiers. For example, on environmental matters, to the borrower's knowledge, there are no violations of environmental law. Another potential mitigation technique is to narrow the definition of knowledge to the actual knowledge of specific officers, preferably identified by name or at least by office. Again, the bank may not be inclined to narrow these reps and warranties simply because they're not in the position, to know either. And so as between the bank and the borrower, the counter argument by the bank is, well, you're more likely to know than we are, so you have to take on that risk if there's a problem. An additional way to carve out non-compliance with reps and warranties as they're written is to create disclosure schedules. And Paige will discuss this a little bit more thoroughly later during the presentation. But if the bank is not willing to make a change to the rep and warranty, either by qualifying it by knowledge or materiality or some other limitation, if they're not true as written, then the disclosure schedules should be prepared to carve out nonconformities. There are two types of disclosures that are made. Negative disclosures are things like, there's no litigation against the borrowers except for case X, Y, and Z. So you're carving out from a general statement of no litigation that there are certain litigation matters outstanding. Another type of disclosure are affirmative disclosures. These are more like a list, so sometimes the bank wants you to list out the collateral, for example, that's being used to secure the loan. So that would be also put into a disclosure schedule.
So Kathryn, why don't we work through on the disclosures what happens? So we talked about knowledge, and the bank's argument is, well, we don't really care if you don't have knowledge. If you breach, you breach, right? And we say, well, we don't know, and as long as we're paying, you can't foreclose us out because we didn't know we had some technical breach of a covenant. That's kind of where that goes. And then on the carve outs, I'm always harking back to that a couple of years ago. So you make a representation or warranty like, we will continue to not break any laws. We're not in litigation. We're very nice people, and we'll continue to make the same amount of money we've always made, which is pretty much impossible. So then you say, okay, except as listed on the schedule associated with this representation. And the idea is that you say, okay, we make the representation except it's not true with respect to these items we put on the schedule. And then a savvy lender's counsel or a savvy, if you're doing a sales transaction, be a savvy buyer's counsel, is like, well, you can make you can make this disclosure, which is an exception to the representation. But if we suffer damages because of that item disclosed, which is, basically your breach of a representation, then we still get paid on the damages. We can still foreclose, etc. But occasionally we'll come across counsel for a bank or for a buyer that doesn't pick up on that. So basically what happens is you put the disclosure there, it's true, we have to do X, we have to, make sure we comply with all the laws, except we've got these few things that we don't really we're not sure we comply with, and they're excluded from the representation. So the bank can never come back and say you breached. And some of the people don't pick up on that once we put it on the schedule, it's completely eliminated from from exposing the client. It's kind of a major point. It's a little technical, but these disclosure schedules are that important.
It's great if you can get it. We were able to negotiate. It wasn't in a bank deal. It was in a deal context, an M&A context, and it was something that could have been a big issue. And we disclosed it, and the bank went ahead and closed anyway. And we had some language in the documentation that said the bank couldn't come back, or sorry, the buyer couldn't come back if there was an issue. And so it's great if you can get it. But usually, the other side is somewhat stingy in giving that language up.
Yeah, the sale deals, the M&A deals are easier than the bank deals.
Right.
Because you're basically, you're asking for cash. And in these workout deals, you're asking for cash and things don't look real good. So your negotiating position is a little weak. But I think we do pretty well with it. You still have to try.
Yeah. Right. Among the reps and warranties that the borrower is going to be making are with respect to the veracity of the financial statements and information that they're giving to the bank on which the bank is making their lending decisions. Because it's so important to the bank that the information that they're relying upon is sound, they're usually very stingy in carving out any changes that would limit the borrower's exposure to breach of warranty claims. Some things that we've tried in the past and with some success have been to qualify the reps and warranties in the ways set forth in A, B, and C on this slide. Point A is relevant if you have multiple entities within a conglomerate that are all going to be somehow party to the loan. And so when you're disclosing information with respect to these entities, you want the bank to view it as a whole. And that avoids a situation where you may have an outlier, and that outlier could lead to a technical breach of the rep and warranty. B and C have had a little bit less success in that what we're trying to do here is limit the accuracy of the representation as of the time made. The bank usually wants a bring down of the rep and warranty whenever there's an advance of additional funds after the initial closing date. So they're usually not inclined to limit the representation to a specific point in time, but it's worth making an ask on behalf of the client. And also point C here, I think there's an understanding that the rep and warranty is limited to what's written and not oral, but lenders usually won't formally sign on in a document to this limitation because it could exclude things that are discussed in meetings or over the phone, which could be substantial from the lender's perspective. We'd also want to, and this is point E, is prospects. The bank usually has some standard language where the financials fairly and accurately represent not just the current position of the company, but also prospects and projections. And we like to exclude that whenever possible because there's just really no way to make representation with respect to prospects without potentially, being exposed to a breach.
One of the ones you can get the knowledge qualifier on. How could you possibly know, what the industry is going to do? I don't even know why they ask for that anymore.
I think it's just standard language that they're used to, and we usually are able to get it out. So whenever we see prospects or projections or anything that's forward-looking, we try to get that taken out completely or at least qualified by knowledge if the bank is requiring that it stay in some form. Another representation that banks typically want is a solvency representation. And the term solvent could have a specific definition in the credit agreement. Sometimes it's just a matter of looking at cash and cash equivalents. Other times there's some more intricate formulas or definitions involved in defining what it means to be solvent under the loan documents. Similarly, we like to have some limitations on the representation. One again is solvency as a whole. If you've got 30 entities and one is insolvent, you don't want there to be a breach of a solvency covenant of 29 or fine. And so we like to make that a representation qualified by the fact that it's solvency as a whole, not just a particular entity. And again, when possible, we'd like to limit the time at which the representation is made, but banks typically are not inclined to do that. They want a solvency representation every time there's a drawdown of funds, for example, under a line of credit.
Yeah, that's a tricky one. That's a tricky one, and the definition of solvency should be pretty loose. Also, there should probably be a little bit, if it's a breach, there should be a time to cure solvency, because different industries, they have seasons, they have different ups and
Right.
downs, and it's a great way to fall into a breach of your loan covenants, the solvency.
Another element of the credit agreement are affirmative covenants. We just talked about reps and warranties. Affirmative covenants are obligations that the borrower is required to fulfill during the life of the loan. And again, when you have multiple loan parties, it could implicate more than just one entity within a conglomerate structure. A typical affirmative covenant is delivery of financial statements. Usually they have to be audited and produced at least once a year in audited form. The bank may require quarterly unaudited statements or some other periodic time of reporting. Sometimes banks have in their standard language that the client has to use a nationally recognized CPA firm. We've been successful in getting that taken out just because one, in small and medium-sized businesses, you don't really have a need sometimes for a large, very expensive CPA firm, and the smaller firms are more than competent to render the audited opinions. So we can usually get that negotiated out. And then another important issue to consider when you're drafting and negotiating these covenants is the amount of time that the client will need to get these audited financials and other financial statements put together. And so you want to make sure that there's sufficient time. Usually, 60 to 90 days after the close of a calendar year, for example, is typically enough time, but that would depend on the client. Additional covenants beyond delivery of financial statements is delivery of certain notices. For example, if there's a default in the loan, the borrower usually has the burden of bringing that to the bank's attention. It's not, the bank isn't, they're getting reports, but they're not constantly monitoring the borrower's condition. So if there's a default in the loan, even if it's a technical default, the credit agreement usually has some timing requirements and when that default must be reported in writing to the bank. Major events like things that could result in a material adverse effect, and that's a defined term within the document. If there's a lawsuit or a large governmental proceeding launched against the borrower, or if there's a material change in the loan party's accounting policies or financial reporting policies, typically the bank will want notice of that, and there's a formal obligation to provide that notice within a certain time frame.
I think this creates a lot of leverage for the bank too. If you have a material adverse effect, half of the clients are like, well, we're having a material adverse effect. The last thing we want to do is tell the lender,
right.
You have two material adverse effects. But if you have it and it actually doesn't work out well, then the bank is in a position to call you in default. So you have to be very careful. It's kind of like an insurance claim. We had a problem. We didn't tell the insurance company because we don't want our rates to go up. But in this case, if you actually do end up losing a lot of money or sacrificing a section of the business, and the bank will call you in default just because you didn't give them notice. You got to be real careful with that.
And there are ways to negotiate or modify the definition of material adverse effect. It's more so in M&A deals and bank deals, again, because the banks like their documents and they're not really willing to change much substantively. But there are ways to, for example, exclude industry-wide occurrences as being a material adverse effect for purposes of a document. So, it's just going into kind of a foot fault scenario. We're trying to advise the client, even if the bank is not willing to change a document, what the potential foot faults could be, and one of them is not timely reporting what would be a material adverse effect under the loan documentation.
Football.
Foot fault,
I like
yes.
that. That's a good term. That's a good tennis term. You step on the line, you serve, you step
That's
on the
right.
line.
You're
Like step on the line. I had a problem with that once in a match as a kid.
you got a toe on the line, and the bank
Well,
is
no,
ready
they
to
got a
yank the chain on you.
linesman, and everything was like a whole, it was a full audience to see where my foot landed after I hit this, it was unbelievable. Yeah, so these are kind of like that's what actually the whole seminar is kind of like, avoid these technical defaults so that you don't end up getting leveraged out on a new loan
Right.
package or lose your loan. Yeah.
Right.
Even if you're playing tennis, I mean, whatever.
On the next slide, we talk about a little bit some additional promises, and these are the more, paying all your obligations, obviously, maintaining your corporate and legal existence. This is one where it's another foot fault. Like, for example, in Florida, if you fail to file an annual report, and enough time goes by, the state could administratively dissolve your entity, and then you have to reinstate and pay a fee. It's not a big deal because once you're reinstated, the existence goes retro to when it was last in place. But it could be a technical default under the loan documents if you're administratively dissolved. Again, you want to build in a cure period or have some kind of materiality threshold in place for these types of obligations.
And Kathryn, I just wanted to add too, if there's more than one borrower or if there's multiple loan parties, it's important to keep everything in check to make sure that all of the loan parties and or borrowers maintain their corporate existence. So if one slips, then you could technically be in default as well for the loan.
Yep, that's a great point, Paige. Thank you. And also, you may find that the loan documents, the bank wants security in what you have and also what you may receive in the future or what you may acquire in the future. So we typically see an obligation in the loan covenants where, if, for example, a loan party acquires a piece of real estate, they have to report that to the bank and then enter into a mortgage securing the loan with that real estate within a certain number of days or months after acquiring that new asset. Another obligation is this number 5 here, account control agreements. If the borrower has most of their accounts at the lender's bank, but they have a few other accounts at other banks, the lender may want a written agreement that gives them control over deposit accounts held at other banks. Where this has come up recently is, in our world, there's the PPP loans, for example, where these larger banks may not be nimble enough to process these loan applications at the rate that smaller banks may be able to take care of that for a client. And so clients may have accounts at smaller community banks simply for the purpose of receiving PPP funds. And so if you have a large national lender who holds the debt on credit facilities, they're going to want an account control agreement to make sure that they have control over those funds in the event there's a default, and they can basically direct the other bank to turn the funds over if it becomes necessary.
Point. That's a good point and raises the leverage issue again. So if you have all your accounts with the lender's almost always going to have language in even a basic loan package. And sometimes even if they don't have it, they take action and they can freeze your accounts. I mean, some people that have suffered this situation where everything kind of shuts down and now the lender's just kind of taken over. You have to be very careful with these operating accounts because they think, oh wow, they just got, the client just got sued, they violated their cut, they were supposed to tell us about that, and they freeze your account. Sometimes we found that they actually didn't have the even power to do it, and they do it. But a lot of times in the loan documents, they have the power to. You've got to guard against that, so that they can't just take unilateral action without at least suing. Happens all the time.
Yep. Let's see. Up next is negative covenant. So these are things that the loan parties cannot allow to occur. For example, other than certain permitted debts that are scheduled in the credit agreement, the borrowers can't incur additional debts. They can't make certain investments. They can't change their corporate structures. In one of the deals that we just did, there was a restriction on the ability to change the CEO. And so these are promises that the loan parties have to abide by throughout the term of the loan. The key to the negative covenants is really in the exceptions to them. And on the next slide, we go through some of those exceptions. So for example, going back to disclosure schedules, typically the bank says they have a general rule where you cannot make certain investments except for X, Y, and Z. We had a situation where the client had made an investment outside of the ordinary course of business in that they extended a large credit to a trade, somebody that they do business with frequently. It was in an amount that was outside the ordinary course of business. It came up in the bank's due diligence. The bank initially thought it was additional debt, and then they took a closer look at the documents and they found it was actually a payable to the borrower, and we had to schedule that out. So even though it was something that was an asset of the borrower, it had to be scheduled out as a permitted investment that the borrower could make without violating the terms of the loan. Going up a little bit to the financial covenants, they also have to maintain liquidity and certain financial ratios. And this is a business term that the management of the borrower and the bank's business team would work out. But these are all things to be mindful of during the term of the loan.
And one aspect of the securities, Kathryn, that's taken is I want to give people a heads up when we get to this personal guarantee section, because the notice on that and changes to your personal structure is key to the other side that is avoiding personal liability with respect to the loan. But it has to do with these covenants. Go ahead. Sorry.
Absolutely. The bank doesn't want to be overly restrictive. I mean, the practicality is the borrower has to be able to continue to operate its business. So credit agreements typically allow for inventory to be disposed of in the ordinary course of business, accounts receivable to be compromised and collected in the ordinary course of business, and the disposition of obsolete property. So the key here is it has to be within the ordinary course of business. That term can be defined in the documents or not, but it would be up to the borrower if it were ever pushed to argue and convince the bank that a particular action was within the ordinary course of business. Okay. All right, next up is organizational documents and due diligence. And I'm going to hand this over to Paige to kind of walk us through this section of the outline. Go ahead, Paige.
Great, thanks, Kathryn. Okay, so when entering into a loan transaction or reworking your loan documents, one of the first things you kind of want to think about and start to organize are the internal organizational documents for your company. These will be important to gather as they'll be disclosed to the bank for part of their due diligence. So the first thing we normally suggest to a client is to compile any organizational documents. So if you are a limited liability company, this would include gathering any articles of organization, the operating agreement and membership certificates for that company. This would also include any amendments that have been done throughout. And then if you are a corporation, this would include your certificate of incorporation, bylaws, and share certificates. So as you're kind of going through, if things aren't up to date or if you see that you're missing something, for example, corporations are required to have annual minutes. So if for some reason you see that one of the years are missing in the annual minutes, now would be a good time to update those missing years and to prepare the correct corporate documents to reflect what happened during those years. So when the bank asks for disclosure of these documents, we can hand them a nice compiled stack of your documents for them to then go look through. Having these corporate documents and then providing them to the bank allows the bank to do verification of the company organizational structure. They're just going to verify certain information that they need as they go through the loan process. And normally we correspond with the bank's counsel multiple times over different questions that may come up during the due diligence process.
It's also a good time to get everything up to date. You know, if you've got an operating agreement that you had, you know, from 1994 that doesn't really work under today's statute, it's probably a good time to get that updated. If you may have issued equity or phantom equity to employees, etc. No one ever tells the bank. Now we want to get that all organized in a real tight, clean package to avoid any issue with the bank.
Right, exactly. Okay, and so the share and member certificates are an important piece of the organizational documents that we send to the bank, as typically the equity is going to be pledged in the loan transaction document. So if for some reason you're unable to locate a share or membership certificate, the original certificate that was signed, normally what we do is we'll have to prepare a loss certificate affidavit, just stating that you performed a thorough search, were unable to find the original certificate for the equity, and then we'll have to submit that affidavit to the bank along with, typically we issue a new share or membership certificate that will supersede and then replace that loss certificate. So they typically like to have the original physically in hand when the equity is pledged. And so alternatively, if the bank's not seeking for the original share certificate, and if that certificate is then lost, the bank can just require that essentially the certificates for that company be canceled. And if they would request that, then we could amend the bylaws or the operating agreement for the borrower to just essentially state that the certificates have been canceled and that none are outstanding at this time. The share certificates are, like I mentioned, are important. They have an important legal significance, as this will help to perfect the bank's security interest in the pledged shares and equity in the company. Typically, towards the end of the transaction, when there's a definitive closing date, we'll send electronic copies of these membership and share certificates to the bank so that they can then review, make sure everything's in order, and then after closing or right at closing, we'll send the original share certificates to the bank for them to have in their possession.
And the bank may also agree to make that a post-closing requirement, particularly if you have a lot of certificates that you're trying to corral. If it is a post-closing requirement, they will state it in the document to formalize the obligation to make sure it's completed within a specific time following closing. And again, the bank's concern is that if there is an original certificate floating out there, it could somehow prime or jump their priority in as far as the status of their lien and their security interest in the equity that's being pledged.
Right, exactly. And then also if there are any missing documents and an update is occurring while you're negotiating this loan transaction, updating the corporate docs and becoming more familiar with them are helpful when preparing the secretary's certificates and or manager certificates, in which you authorize certain individuals, such as the CEO or the president of the company, to sign the loan transaction documents on behalf of the company. So in this way, as we're updating the corporate documents, we can ensure that those documents reflect who the current CEO is, or if there's been a change in the prior years to who the current CEO is at the time the negotiations are going on.
Mhm. And typically the banks, they have post-closing departments where it may be non-lawyers who are looking at everything that's been signed to make sure everything is done correctly. And they will go just based on what the secretary certificate says. So they'll rely on that. And so before it gets to that point, the counsel to the borrower will want to make sure that those certificates are actually backed up by the underlying LLC organizational documents or the corporate documentation.
Right, exactly. The signature blocks on the most recent deal we were working with had to line up exactly like Kathryn had mentioned with what was included on those secretary certificates. Okay, so the next part is talking about the disclosure schedules. I know we had mentioned this previously, but the disclosure schedules are the main part of the due diligence process that we work through with the bank's counsel. Usually, once the credit agreement begins negotiations, the schedules will be incorporated in the credit agreement. So when the schedules are mentioned, the borrower will usually initially prepare the schedules, going through the credit agreement, reading those reps and warranties very carefully to make sure everything is true as written. And if anything is not true, then we would also need to make a note of that and then put that on a separate disclosure schedule if the schedule is not already included in that credit agreement. So it's very important to make sure those reps and warranties are accurate. So the borrower, like I mentioned, will prepare the initial round of the schedules, but it normally takes multiple rounds with the bank's counsel to get the schedules in a final format. So as we're going through, the issues narrow during each turn of those disclosure schedules, where the bank's counsel will normally point out a specific area of inquiry. We'll ask a few questions and things like that, maybe to receive more information than what was initially put on that first draft of the disclosure schedules. So it just takes a lot of back and forth to really narrow down the information that the bank is specifically looking for, and then the exact format that the bank is willing to accept as well, along with including all of the information that the borrower needs to include in those schedules. So it's quite a feat to make sure everything is disclosed properly. And another part too, as there's numerous rounds of revisions with these bank loan documents, is to make sure that the schedules don't change during the negotiations. So if a schedule is for some reason no longer included in the credit agreement, you'll need to make sure that that change is also reflected in the information that's included in the schedules and the actual disclosure schedule itself. So it's very important to just monitor and keep in mind that the credit agreement is going through numerous changes. So the schedules will also need to align with what's in the latest version of that credit agreement.
Okay. Nice overview.
Thank you. And the last point that I wanted to touch on were the certificates of good standing. These certificates are usually ordered from the state of formation in which the LLC or the corporation has been formed, just saying that everything is up to date, the company's in good standing as of a certain date. So the date that these certificates of good standing are ordered is an important piece for this due diligence process. So the bank will require that the certificates of good standing be ordered within a certain date range. This could be 30 days or less of closing. Typically, we see that the bank would like them to be ordered within 10 days of closing, 10 days or less of closing. However, this can be a little bit tricky if there's not a exact closing date determined yet, or if it's a fluid closing date that's rapidly changing as things progress. So it's important to be mindful of an anticipated closing date and potentially not ordering the certificates too early, as you may need to reorder if for some reason the negotiations don't close as expected. So that way everything is current and within the bank's time constraints for those.
I want to mention one thing, Paige, on that is that these certificates of good standing, typically it's kind of a non-event. I mean, you order it and it's there within a certain number of days. You may have a situation where you order the certificate, but for some reason the state cannot issue it. For example, if there is an outstanding state tax debt owed to a Department of Revenue of a particular state, the Department of State may not issue the certificate. So, it may be necessary to order a certificate more than once to see if there's any issues, and if there are any issues, resolve the issue and then order again so you can produce a clean certificate of standing to the borrower or to the bank prior to closing.
Right, exactly. And also if there's been any organizational changes that have occurred during the negotiation of the loan documents and things were filed with the state, you have to also make sure that that certificate of good standing includes any amendments to the articles of organization or articles of incorporation to include the full facet of what's happened. Okay.
We're getting close to the end. If anyone has any questions, please, click the question bar, and Tony will let us know.
Okay.
This is kind of a big deal. This one here, we typically, what we like to see is if a client, is an established client, their business has been around a while, typically the banks will forego the requirement of a personal guarantee by the individual principals of the business. And so that's always a good thing when your client, the individuals are not going to be held personally liable for the debt. What you need to watch out for, though, are what we call functional equivalence of a personal guarantee. For example, like Paige and Gary mentioned earlier, typically the bank will require a pledge of the borrower entity's equity to secure the loan. One of these functional equivalents could kind of creep up in the pledge agreement whereby the individual owner is pledging their equity, but there's some other language within the pledge agreement that says that the individual owner will be liable for any deficiency in the event that the value of the equity is insufficient to cover the debt. And so this had come up in a deal we just closed up, and the bank, the counsel didn't catch it, or it may have been new counsel on this deal, this iteration of the loan that wasn't involved in the prior, the original loan, and so we caught it. And it caused a little bit of a stir on the client end because their understanding all along was the bank's not going to require a personal guarantee, and now it's kind of creeping up in a backdoor fashion. And so we were able to get the bank to back off. It was honestly an oversight, but you have to be careful in that the bank's counsel may not catch it. And so what we do is in these any documents where the individual owners are a party to the document, we look out for deficiency language. We try to get it struck, and even better to have language to the contrary that says they are not liable for any deficiency. Essentially, that the bank's only recourse against the individual owner would be the pledged shares, to avoid a situation of inadvertently exposing the individual owner's personally held assets to the bank's the debt on a commercial loan.
That's a great point, and you should also keep in mind, if you're the lender, once you go through the process, if in fact there is some sort of personal guarantee, your issue becomes one of fraudulent transfer. In other words, you've got a guarantee out there. When you made the guarantee, you weren't able, you didn't have time, you didn't have counsel, or however it worked, to structure your assets such that the guarantee may not be of any value. So it does have value. In other words, you have assets that are exposed to the personal guarantee. It doesn't mean you can't plan around the guarantee. So what happens is you can still take action to structure your personal assets. It is subject to the rule that says you can't move anything around against the lender, so the lender can go get it. So the issue becomes, this is a very key issue on a lot of these guarantees, is okay, I restructured personally, not just for the bank, but I restructured personally for estate planning and for, you know, asset protection purposes. And I want to tell you, lender, that I did that, because I have to tell you, I'm under a notice requirement. I've done that, right? Typically, it doesn't require consent. A personal guarantee with respect to the actual assets held by the guarantor doesn't require consent. It's not like a covenant. But you tell the lender. So what happens at that point is that the rule empowering the lender to sue you for any reason, okay? You didn't breach the agreement. You didn't breach the covenant, but in case that loan went into default, they'd have the ability to reach your personal assets. You have now started the clock on that, right? And in Florida, that's a 4-year clock. So you have to let them know that you restructured or you did planning. And after 4 years, those assets are likely not exposed to that lender. It's very significant. Different states have different statutes of limitations, but I wanted to mention that because although this is a lender-based seminar, that personal guarantee issue is a massive, massive substance issue with respect to the client.
Thanks, Gary. I think we're running a little short on time, so I'm going to skip over part 5. This is cross guarantees and additional collateral, and move on to the legal opinions portion of the seminar. If you have any questions regarding anything we skipped, please feel free to email us or pop in on the chat. Legal opinions this is kind of a weird thing in that the banks typically, sometimes the banks won't even require a legal opinion to close a commercial loan. We see it more often when there's a modification. The bank may have foregone the requirement early in the process, and when they're trying to, establish a relationship with a particular borrower. When the loan is re-upped, though, they may require legal opinions. And then what they are, in essence, is the bank's counsel, or the bank is wanting the borrower's counsel to essentially opine on or guarantee certain matters with respect to the loan documents. In point B here, we list some of the opinion coverage, the typical things that the lenders are going to want to see as far as coverage of a legal opinion. Quite frankly, it's difficult for a law firm to give a legal opinion if their engagement is limited, for instance, to exclude due diligence or independent investigation or review. And so, we try to negotiate the scope of the legal opinion down to basic matters of legal existence and authority under the governing documents of the borrower entities, because that's what we're already being asked to look at for purposes of closing the loan. Where the banks get a little bit antsy is if you're not willing to opine on other things like lien attachment and priority, or if you're not willing to opine without a broader engagement with respect to third-party obligations and contracts. So again, the legal opinions, in my opinion anyway, are somewhat antiquated in that the bank doesn't really need them to close, but they usually want them. And so we try to limit the scope.
It's interesting, right, Kathryn, because the lawyers that they're asking them for don't represent the bank.
Yes, that's right.
The bank has their own lawyers to make all of these inquiries and do legal due diligence and check the liens and check the statuses of the companies. So they're asking the other lawyer. It's a holdover from the 50s. The banks, nobody else does it but the banks. No M&A deal, nothing. And they still want, they call it comfort. We want comfort on these liens. And I, Kathryn and Paige usually let them know that they're going to be very uncomfortable because we don't represent the bank. And if the bank wants legal work done, they should probably ask their counsel. So these stuff from a good lawyer representing a borrower perspective, really, it's very limited. It's very, very limited. And oftentimes, like Kathryn mentioned, you can just negotiate it away at the beginning. Like, hey, our lawyer understands that you may want something from them, even though you have a counsel, and you're not going to get it. And they kind of, and a lot of times they'll waive the requirement.
And just, a practical thing from the client's perspective for the borrowers is that it costs additional money. It's going to drive up the cost of the transaction. Again, the borrower is paying for both sides of the transaction. It could be uncapped unless there's a cap negotiated up front. And so, the need for legal opinions, and sometimes you have, 5 or 6 jurisdictions involved. And so unless you have a lawyer who's licensed in all 6 jurisdictions, you're going to need to involve outside counsel to render portions of the legal opinion or separate opinions. So it can be very costly for the client. And again, we try to negotiate down the scope of the legal opinion in an effort to save a little bit on the client's end from a fees perspective. Closing remarks, basically, takeaways are to get counsel involved early if you can from the borrower's perspective. The last deal we did, we were brought in a little bit late to the game, but we were able to get it done. And we were actually asked by a solo practitioner to handle and step in as U.S. counsel. So we've got, we staffed it with 3 lawyers plus additional lawyers on our team as needed. And it still took quite a bit of work to get it done. So get lawyers involved early if you can, negotiate your cap on legal fees, and also watch out for these kind of backdoor ways of establishing a personal guarantee when one isn't intended or contemplated by the client.
We know it's not the most exciting topic, but I found it kind of exciting, and it's very relevant today. There's a lot of these these kind of technical breaches going on with the loans, a lot of redoing of these loans. Be careful, and we thank you for attending.